Hello, my name's Andrew Johnson. It's my pleasure to welcome you to this first 5 Paper Buildings webinar. We have 3 great talks coming up. In a short moment, OSullivan QC and Dominic Lewis will talk about the Coronavirus Act and the accompanying health protection regulations. David Osborne will then review some recent cases. And last but not least, Teresa Hay will talk about applying the principles of dealing with vulnerable witnesses in other contexts. It may be your first time attending a live event hosted in Microsoft Teams. Well, it's our first time hosting one too. I can't promise the technology will work perfectly, but we will do our very best. Before we begin, you should see on your screen, I think towards the right-hand side, a question and answer panel. Please feel free to submit any questions as we go along, and then we'll endeavour to answer a selection of them at the end of the event. It's now my pleasure to introduce and hand over to OSullivan QC.
Hello. This part of the talk addresses in summary form the powers which the state has enacted in the criminal field over its citizens in response to the current pandemic. The Act which I'm going to deal with, the Coronavirus Act 2020, deals with restrictions in this regard on persons who have or may have the virus. And then Dominic is going to deal with some regulations that were made under a different act, which deal with the general restrictions on the movement of everyone, whether symptomatic or not. The Act itself, the 2020 Act, is quite big, 120 sections, 29 schedules. It took just 6 days to go from its first reading in the Commons to receiving royal assent, and so received very little scrutiny. It has a sunset clause, 2 years, but after the expiry of every 6 months, the House of Commons must approve the remaining in force of the temporary provisions of the Act, and those temporary provisions include the powers I'm going to deal with. And I'm going to concentrate on just one of those 29 schedules, that's Schedule 21, which is brought into force by Section 51 of the Act. And Schedule 21 confers powers relating to potentially infectious persons and makes related provision. And there you see on the slide the definition of potentially infectious persons. It's not particularly illuminating. In respect of paragraph 2b, the reference to an infected area there is a reference to overseas territories where it's thought that there's a risk of human-to-human transmission. And bearing in mind what we read in the papers, that a number of flights into airports in this jurisdiction, which are still open, have on them various people coming into the country who are not subject to any checks on their arrival. You wonder what the purpose of paragraph 2b actually is. Also, there's no definition of coronavirus symptoms. Perhaps you wouldn't expect them to be, as they seem to be changing on a reasonably regular basis, or at least updated. Perhaps we should refer to the Public Health England guidelines. The moral, it seems to be, is don't cough if you go out in public. Now, these powers are given to 3 categories of officers. Public health officers. Such an officer is not defined in the Act or the schedule. It's just someone who is designated as such by the Secretary of State for Health. Also, immigration officers and police officers. And these 3 categories of officers have these powers during the transmission control period. And we're in one now, and that period will continue for as long as there is a serious and imminent threat to public health, within, of course, the sunset clause for the whole Act and the 6 monthly reviews by the Commons. So when can these officers exercise the powers that we'll come on to in a moment? Well, Andrew, can we have a slide 2, please? You can see there that under those various paragraph headings, those are the paragraphs which give the powers, and they can be exercised only when there are reasonable grounds to suspect that a person is potentially infectious, and that the exerciser of the power considers that it is necessary and proportionate in those 3 ways. Now, the powers can be exercised at 3 different stages: going to a testing centre, whilst you're at a testing centre, and once you've left. So if we deal with them briefly in turn, and Andrew, you can put the slide down now, thank you. A public health officer can direct a person who he has reasonable grounds to suspect is potentially infectious to go immediately to a place for screening and assessment. He also has the power to remove a person to that place and ask a constable to remove the person to that place. An immigration officer and a police officer has the same powers, but must consult a public health officer before he exercises them, but only if practicable to do so. So pausing there, assuming that your immigration officer or your police officer is not medically trained, if there is no public health officer around, it's unclear how they're supposed to carry out a diagnosis on the street. There's certainly no guidance that I've seen that assists them. Perhaps this risk of coughing in public is, after all, no joke. Well, what happens secondly at a testing centre? Well, the public health officer may require the person who's been sent there to remain for 48 hours. And that requirement may be enforced by a police officer, well, one can understand that, or the public health officer. Quite how a public health officer exercises that power to require a person to stay is not clear. The public health officer may also require a person to be screened and assessed, to give samples and allow healthcare professionals, who thankfully are defined, to take a sample, answer questions about health and other matters, including the person's travel history, produce documents, and provide contact details following the person's release. Whilst the person is at the testing centre, having all those requirements required of him by the public health officer, the police constable and the immigration officer may simultaneously keep the person there. By keep, presumably it's meant detain, and the period the person can be detained is 24 hours if it's a police officer, or 3 hours if it's an immigration officer, respectively, and then a further period of 24 and 9 hours, respectively, if there is authorization from a senior officer. So that gives you a maximum of 48 hours that you can be detained. Just pausing there for a moment, if you're being potentially detained against your will for the 48 hours, what are your rights? You're not under arrest, you've not committed any offence, the PACE protections don't apply to you, and there's no code of practice. Thankfully, for the citizen, the schedule says at paragraph 21 that the 3 categories of officers must have regard to the guidance. What guidance there is not clear. The College of Policing have issued some guidance, but that simply repeats what the paragraphs in the schedule say. The only rights you do have is to be given the reason for your detention, the maximum period for which the detention has been authorised, to be told that if you abscond, you're committing a criminal offence, and you're entitled to have those matters given to you at some point in writing. There's no right to legal representation. There's no right to inform anyone of your detention, although, of course, you're not prevented. This is not prison, after all, from doing so if you have a mobile phone with you. Perhaps importantly, there's no protection from self-incrimination by being required to answer questions. Being required to answer where you've been may be very valid from a public health perspective, but if the answer is you've been somewhere where a crime was being committed, for example, a Regulation 6 offence that Dominic may come on to, you might be incriminating yourself. The third stage at which the powers will be triggered are after you've left the testing centre, and there are various requirements to provide information as to your future movements for the next 14 days, with an extension of another 14 days. What then finally are the sanctions for breaching any of these requirements? Well, you can commit a criminal offence. Paragraph 23 provides that it is a summary offence, punishable by a level 3 fine, that's £1,000, if you fail without reasonable excuse to comply with any direction, reasonable instruction, requirement, or restriction imposed by those 3 categories of officers, or if you knowingly provide false information to them, or you obstruct them in the exercise of those powers. It's likely, as with many statutory offences with similar statutory defences, that there is a reverse burden here on the defendant to establish the reasonable excuse on the balance of probabilities. Well, I'm not aware, you may be, of any citizen who has been subject against their will to the exercise of these powers, draconian though they are. That may be mostly because these powers are exercised by consent, as people who have symptoms actively want to be tested and treated. But after the transmission control period is over, there may be some complaints about unlawful detention. We just have to wait and see. It is perhaps more likely that the real-time complaints will occur in respect of potential breaches of the regulations, which Dominic will now speak to you about. Thank you, Andrew.
Good afternoon. Well, I'm taking over and dealing with the snappily titled Health Protection, Coronavirus Restrictions, England Regulations 2020. You've heard this referred to as lockdown and the like in recent days. And what I want to do is rattle through the key parts of the regulations at some pace, and there'll be a fair number of slides. They'll be up on screen and they can be made available at the end, and the references will be on the slides for all to look at. The first important point to note is, of course, that while this is a talk about what the law permits and what the law prohibits, it is far from, obviously, public health advice. The law, in fact, permits a fair amount that government advice currently cautions against. And of course, we should all be doing what we can to comply with that advice. But this is a talk about the law, the regulations, and what they allow. And the next slide gives an example of a potential conflict between the law and the advice that's out there. There you are. Went for a second walk. Should you end up in Shawshank or simply the doghouse? Are you breaking the law, or are you simply not doing your best to comply with government advice in order to better protect public health? Well, that question is going to be answered in due course in this talk. But I want to move first of all to look at the purpose of the regulations. That's set out in Regulation 3.3. You see it there. It is plainly, on any view, a weighty purpose, and it justifies, on any view, perhaps, the restrictions that are imposed by the regulations. The power to make the regulations is conferred by a 1984 Act brought in to deal with a different pandemic. There's an interesting academic debate going on at the moment about jurisdiction, virus, pun fully intended, no doubt, but that's not what I'm going to be talking about today. What is important, though, to note is that the interpretation of the regulations will be guided by that purpose. And so what's reasonable or necessary or proportionate and so on will all be judged with reference to that Regulation 3.3 purpose. On the next slide, the nuts and bolts of commencement and so on are set out. As we all know, they've been in force for about 2 weeks now, from the 26th of March. That's the start of what's defined as the emergency period, and we'll see that phrase crop up as we go through the regs. The regulations must be reviewed once, or the operation of the regulations, at least once every 21 days. The first review needs to be by the 16th of April, but as you may have seen today, there's talk of bringing that review forward, and the government's empowered to do that. It can't wait longer than 3 weeks between reviews. And if any of the restrictions and requirements are no longer necessary for the specified purpose, they must, of course, be terminated. In any event, the regulations expire 6 months after coming into force, so in late September, unless something's done to extend them during that time. That's the sunset clause provided for by the regulations. On the next slide, just set out briefly the various categories of restriction and requirement. With those relating to businesses and premises in regulations 4 and 5. I'm not going to be dealing with those today, but effectively the requirement to close your business, close your premises is made under these regulations as well. But we're going to be looking at restrictions on movement and restrictions on gathering, which is set out in regulations 6 and 7. They're the most pressing, they're the ones that we're most likely to encounter in our daily lives. So if we look first at Regulation 6.1, and it's worth just pausing to take a moment to read those words and let them sink in. During the emergency period, no person may leave the place where they are living without reasonable excuse. And that, on any view, while one understands the reasoning behind it, is quite a staggering restriction on what we normally take to be our liberty, our right to go and come as we choose. It's particularly significant, of course, because contravention is a criminal offence under Regulation 9.1b. Maximum penalty in the Magistrates' Court, of course, an unlimited fine. And it gives rise, Regulation 6.1, to 3 important questions, 3 obvious questions perhaps. First and most obviously, what amounts to reasonable excuse? Secondly, who bears the burden of proof on that issue? And thirdly, what if the reasonable excuse expires while you're out, after you leave your house? We'll look first at the categories of reasonable excuse. And Regulation 6.2 sets out a non-exhaustive, albeit lengthy, list of what will amount to a reasonable excuse. It's worth bearing in mind the express wording of Regulation 6.2, which says, for the purposes of paragraph 1, a reasonable excuse includes the need, and then the list follows. So that need, that word need, is likely to be quite significant when it comes to interpreting the regulations. So what is included? Well, the need to obtain basic necessities, of course, food, medical supplies, and so on, either for your own household or for vulnerable persons. They're defined in the regulations as you see there on screen. The need to take exercise provides you with a reasonable excuse to leave the house, but only if you're exercising alone or with other members of your household. If you need to see medical assistance, of course, then you're permitted to do so outside the home. And in fact, there's a relatively wide range of listed specified medical services that you can access during this time. They include dentists, opticians, vets, and others that might not perhaps be the most pressing in certain circumstances. Plainly, a vet could be, an optician less likely to be required for urgent need. Nonetheless, a permitted exception. You can leave home to give blood. You can leave home, over the next page, to travel for the purposes of work. You can travel for the purposes of work. You can travel for the purposes of providing voluntary or charitable services, but only where it's not reasonably possible to do that from your home. It's worth noting, perhaps, there's no restriction on the type of work that you can travel for. There's no category of essential work within the regulations that is bound by this. But of course, a lot of businesses will be shut by virtue of regulations 4 and 5. You can leave home to attend a funeral if it is a member of your household or a close family member whose funeral you're attending, or exceptionally, if no one from either of those categories is attending, you can attend as a friend. And there's in fact no upper limit on the number of attendees, provided each of them meets those criteria, one or other of those criteria. Of course, you can leave home to fulfill a legal obligation. And over on the next slide, the non-exhaustive, pretty broad list also includes the need to access critical public services where they're still open and available to you, to facilitate contact for a child of separated parents, and for ministers of religion to go to their place of worship, but only for certain specified purposes. They include performing funerals, of course, broadcasting services from the place of worship, and if the place of worship is open, to provide essential voluntary services, and that's to act as a food bank or other effectively non-religious purposes. You can move home where that's reasonably necessary during the emergency period, and you can leave home, of course, as we would say, to avoid injury or illness or escape a risk of harm. And next slide, please. And so what that means is if you tick one of those boxes, then that will amount to a reasonable excuse for leaving the house. It's not an exhaustive list, but plainly it's pretty lengthy. Reasonable excuse will be judged by reference to an objective test. It's likely to be interpreted, of course, with regard to the purpose of the regulations and the latest advice from the government, and it's likely to be interpreted restrictively given first the number of identified exceptions and secondly the purpose of the regulations, the protection of public health. Walking the dog, I would have thought, would be fine, but if in doubt, the touchstone should be that word need. Do you need to leave the house for the specified purpose? Of course, the next question that arises is what happens if your reasonable excuse expires while you're out? And you see some examples there on the page. If you leave home for one purpose, stay out for another. Perhaps it may be worth considering whether the words or remain away from should be added after the word leave. Certainly that's the way that the regulations are likely to be intended to be read, and we should all guide our behaviour, I would have thought, by that broader test, but it's not on a literal reading of the regulations what would be required. You could leave the home for one purpose, stay out for another, without taking a literal reading, infringing Regulation 6. So if we move on to the next slide, we look at the offence, contravention of Regulation 6. Set out there, Regulation 9(1)(b). The particulars of the offence as pleaded are likely to mirror those relating to possession of an offensive weapon and the like, and the burden of proof appears to me to fall on the defendant to establish a reasonable excuse. That's implicit from the wording of the regulation, and particularly when one bears in mind the purpose of the regulations and the relative ease of discharging the burden on the prosecution or defence in a case such as this. Burden of proof on the defendant, that would mean the standard of proof, of course, would be the civil standard. Move to the next slide. There are, of course, powers of enforcement that fall short of prosecution. Regulation 8(3) gives a relevant person, is designated as a constable, PCSO, other persons designated for that purpose, gives them powers to A, direct somebody they believe to be outside their home address without reasonable excuse, direct them to go home, and B, gives them power to remove them to the place where they're living, so to take them home, and they can use reasonable force if necessary to effect removal. It's worth noting that the College of Policing guidance, which is playing catch up as perhaps everybody else is at the moment, sets out in relatively clear terms that enforcement will be a last resort. The 4 E's, a 4-phase approach described as the 4 E's: engagement, explaining, encouraging, and finally enforcement. So this, the Regulation 8(3) power, is likely to be about as far as most forces will go, but plainly if you don't comply with that there may be consequences. We'll look at those in a while. Moving on to the next slide, a couple of FAQs, and one arises from the image at the start of this talk. How many times a day can you leave home to exercise? There's no express limit in the regulations, but of course the government advice is only leave home once a day for the purposes of exercise, a maximum once a day. Question over whether exercising on your own can ever become unreasonable if repeated in a day may well be, in my view. It may well be possible to read that as being an offence, unreasonable exercising, because of course we have that word need that is always the touchstone there. If you need to go out to exercise once a day, then of course you may. If you need to go out to exercise twice a day, you may, but how many people actually do? That would be, I suppose, the question, if that were ever tested. Another question that's arisen recently: can you drive to a beauty spot to go for a walk or a run or a bike ride? I would say not necessarily. There's a distinction between the way that the exceptions for work and exercise are set out in the regulations. You can drive to your place of work. There's no reference to being able to travel for the purposes of exercise. Arguably, of course, there would be if you needed to travel for the purpose of exercise. So that's Regulation 6. Moving now to Regulation 7, which we'll deal with rather more briefly. This is the restriction on gathering. No person may participate in a gathering in a public place of more than 2, save in certain limited circumstances. Here we have an exhaustive list of exceptions. I'll circulate the slides rather than reading them out, but they overlap to a considerable extent with Regulation 7. We can skip onto the next slide now. Regulation 7, contravention is only an offence if committed without a reasonable excuse. The burden of proof again likely to fall on the defence to the civil standard. Words participate in gathering appear to me at least to be ordinary English words that don't need any explanation. Certainly they're not defined in the regulations. Plainly picnics, barbecues and so on would be comfortably caught by that. On the next slide, the powers of enforcement in relation to Regulation 7 are set out. If we move over, Andrew, to that, and a relevant person, again a constable and so on, may direct a gathering to disperse, you may tell people to go home, or you may take them home as per breach of Regulation 6. Again, may use reasonable force. They've also got very broad powers in Regulations 8.1 and 8.11. You see them set out on the page there. What do they mean? Well, at the very least, they would justify or permit the tipping over of a barbecue that was being conducted in breach of the regulations. Move now quickly to the other offences that are covered in the regs. Contravention we've dealt with. Obstruction is an offence. Contravention of a Regulation 8 direction or failure to comply with a reasonable instruction is an offence. Companies can commit offences under the regulations, although that's most likely to apply to breaches of Regulations 4 and 5. There are some ancillary powers granted by the regs. The power of arrest without warrant has been expanded to include the following purposes of arrest. They're set out there. And a fixed penalty notice may be issued to anyone the constable reasonably believes either both has committed an offence under the regulations and is over 18. Whether they reasonably believe somebody to be 18 or not appears to be the test, rather than whether they are, but that may be a kink to be ironed out in due course. Fine levels you see set out there, but of course, if the College of Police and Guidance is being followed, it's unlikely that one will need to get to the stage of issuing fixed penalty notices. And I think the police are disinclined to engage with those to any extent greater than that necessary. Dealing finally now with the powers in relation to children, the last slide here. Children are treated slightly differently under the regulations. They can be made subject to directions and instructions to go home, etc., but compliance with those directions is left to the adult with responsibility for the child. They can't be issued with fixed penalty notices. They can be prosecuted for the Regulation 9 offences and so need to comply with Regulation 6, staying at home, and 7, not gathering in a public place. Short, to summarise, they may be seen but not heard. That of course would be a breach of Regulation 7. Thank you very much. The slides will be circulated, and I'm going to hand over to Teresa